Supreme Court News with your host, Greg Butz. Tonight's episode, Gender and Intermediate Scrutiny.
Hello and welcome to Supreme Court News. My name's Greg Butz. The Equal Protection Clause of the Constitution says that no state shall deny any person within its jurisdiction equal protection of the laws. So how does the Equal Protection Clause come into play when there is a law that classifies based on gender? What's okay? What's not okay? And how does the Supreme Court come to that answer? They told us in their 1976 decision, Craig v. Boren, in order for a law that classifies based on gender to be constitutional, it must pass intermediate scrutiny. But before I get too far into that subject, let's put standards of review in context. Laws that are challenged under the Equal Protection Clause must be reviewed for their constitutionality. But not every classification warrants the same level of review. The least searching level of review is rational basis. Laws undergoing a rational basis review must be reasonably related to a legitimate government interest. They cannot be unreasonable or arbitrary. A court will often help the state come up with legitimate reasons that might support the law. The court will review a law under rational basis if the law classifies under some non-immutable trait, such as age, weight, or economic status. On the other side of the spectrum is strict scrutiny review. This is the most searching form of review, and any law that invokes strict scrutiny review is highly suspect. In order for a law to pass strict scrutiny, it must be based on a compelling state interest, narrowly tailored, and have no less restrictive means of achieving its goal. A law is subject to strict scrutiny review if it classifies by race, religion, or national origin. Now that we've discussed the difference between rational basis and strict scrutiny, we have the foundation we need to talk about intermediate scrutiny and how that comes into play with gender classifications. The court didn't just come up with intermediate scrutiny out of the blue. It developed over a series of cases. In 1971, the Supreme Court decided Ree v. Reed. An Idaho statute stated that if there were several persons claiming and equally entitled to administer an estate, males must be preferred to females. The Idaho Supreme Court held the law as valid because its objective was to eliminate one area of controversy that the court had to hear. The Supreme Court struck down the law. They stated to give mandatory preference to members of either sex over members of the other, merely to accomplish the elimination of hearings on the merits, is to make the very kind of arbitrary legislative choices forbidden by the Equal Protection Clause of the 14th Amendment. They stated that a classification must be reasonable, not arbitrary, and must rest upon some ground of difference having fair and substantial relation to the object of the legislation, so that every person in similar circumstances is treated alike. This resembles rational basis, but rational basis does not require that the relation be fair and substantial. This is just the beginning of the story. The Supreme Court looked at this issue again just 2 years later. In Frontiero v. Richardson, male members of the uniformed services were not required to obtain proof that their wives were dependents in order to receive certain increased benefits. However, female members were required to obtain proof that their husbands were dependents. The Supreme Court struck the law down, but could not get the court to agree on the same reasoning. 4 members of the court, led by Justice Brennan, said that our nation had a long and unfortunate history of sex discrimination. They held that classifications based on gender, just like classifications based on race, are inherently suspect, and therefore must be subjected to strict scrutiny. 3 other members agreed with the outcome, but said the decision should not be based on strict scrutiny. The ruling should have been based on Ree v. Reed. So at this point, we're wondering, what kind of scrutiny should gender-based classifications be based on? Rational basis? Strict scrutiny? But for that, we turn to our special correspondent, 1976 Fraternity Bro. Fraternity Bro, how you doing?
Bad.
Oh, it sounds like you're doing terrible.
Real bad.
So what happened? So I go to the store to pick up some brew, and I say to the store clerk, "Hey man, give me your maddest brew." And he says, "Okay, how old are you?" And I say, I'm 20, bro. And he says, "Sorry, can't sell you beer because you're only 20. My girlfriend walked into the same store an hour later and she could buy the Mad Brew. And she's 19. Apparently, the Oklahoma legislature passed a law that says women can buy beer at 18, but men have to wait till they're 21. Why? They said it was for traffic safety. Well, what are they basing this off of? They say that men who are age 18 to 20 are more predisposed to drinking and driving than women are who are of the same age group. They have a study that says, in my age group, 0.18% of women were arrested for drinking and driving, and 2% of men were arrested for drinking and driving. But it's not illegal for me to drink beer. Just buy beer. So you can't buy hard alcohol either. No, I can still buy rum for my famous punch. You guys must have some pretty strong beer in Oklahoma. That's the thing. Here in Oklahoma, we only have beer that has 3.2% alcohol volume. That's supposed to not even be intoxicating. Now, I can't even buy my favorite brew, bro. I am so sorry, sir. This must be so hard for you. Yeah. So then you must be pretty happy with the decision in Craig v. Boren. Yeah? Yep. The Supreme Court struck down the Oklahoma legislation. The majority of the Supreme Court held that classifications by gender must serve important government objectives, and, with language similar to Reed, must be substantially related to the achievement of those objectives. But unlike Reed, the Supreme Court used a new standard. Not rational basis, not strict scrutiny, but intermediate scrutiny. Laws that classify based on gender must serve an important government objective. Future cases would hold that this objective must be exceedingly persuasive. Additionally, the law must be substantially related to the important government objective. In Craig v. Boren, the Oklahoma statute failed intermediate scrutiny. Traffic safety represented an important government objective, but the law was not substantially related to its purpose. Young men could still buy liquor. Oklahoma considered 3.2% beer non-intoxicating, and the statistics behind this law were too tenuous. Therefore, the Supreme Court ruled the legislation unconstitutional. So what do you think, 1976 fraternity bro? Hooray! Let's celebrate, bro! Pass me a beer! What? 3.2? So, intermediate scrutiny still lies a lot closer to strict scrutiny than it does rational basis, but it still lies somewhere in between. I hope you enjoyed this edition of Supreme Court News.